Hello, ladies and gentlemen. Hello, hello. I'm using a new video recorder here. This is say hello to your favorite white supremacist, racist, and cult leader, King Picklefuck himself. I already recorded this whole video. This is a video on the Anthony Susan B. Anthony case, which is the most incredible case ever, and somehow the file got corrupted, and so I've been playing Alan Wake 2, which is a very, very cool video game. One of the coolest video games I've played in a long time, and I've been doing like a lot of changes and stuff to my computer because that game seems to want to crash a lot on me. So now all the changes that I've done, and I've got new equipment and stuff too because I'm trying to get ready for 2.0. So the frame rate's a little lower on this, which I'm not thrilled about, but everything else seems to be better. Working the camera is going to be a lot better for me and stuff, so I'm testing this out. If you guys can give me any feedback of what you think. I'm not even sure most people are even going to notice the frame rate. I think I normally do 60 frame rate, and this is a 30 frame rate. I'm not entirely sure. I'm pretty sure. But like the lighting, I have a lot lower than I normally do, which is really nice because it it practically blinds me. It's like painful, and I can move the camera back and forth by just double clicking over here, which is like totally game changing for me or for us because normally I'm switching back and forth down here trying to figure out which camera to put on. So I think this is going to be good. This is called Loom. I'm not saying that as any sort of sponsorship. I'm just telling you what it is. So I'm just testing this out. If you guys could just give me some feedback down in the comments, I'd appreciate that because this might be, you can see I can use like a little marker thing too, which I might use. It just kind of goes away after a second. I can kind of circle and then like make a line like this, and I can like do stuff, and I can go across the whole screen like this. And then if I don't do anything for like 3 or 4 seconds, it just vanishes, which is pretty cool. So, and then I can also do confetti. Just fucking retarded, but kind of goofy. So, yeah, I just kind of would like to get some feedback on what you guys think about this differently than how I normally shoot, because for me, it's going to be a whole lot easier. And I think for you, it's going to be better because I'm not going to have my attention on going back and forth on the camera. Whenever I want to talk to you, I'll just blow myself up like this. And then when we get back into it, I could just pop back down here and I can move myself around. It's really, for me, it's really nice. So if you guys are cool with it, I'd like to know in the comments because this is probably where we're going to take this thing for 3.0. I think this would be a good avenue for it. Anyways, with that said, let's take a look at the Susan B. Anthony case. This is going to be a really, really important video. One of the most important videos I've done in a long time because in this final opinion, the judge says some stuff that I've been trying to find a judge saying. There's 2 bombshells, nukes, like epic, like literally like some of the pieces we've been looking for. We've got 2 of some of the biggest pieces we've been looking for in this case, and it's just like mind-boggling. This video here is not really an optional video. I'm gonna project this as like a you have to see this one. This is like a holy shit video, like oh my god, like holy fuck, like everyone needs to see this. Share this with all your friends and family. Like normally I just send out an email and I just post up new videos that are available. Well, this one's mandatory. Everyone has to see this one. Okay. So back in the day, we got Susan B. Anthony. Let's see this crazy broad. Here she is, and everyone knows her as the women's right to vote lady, right? Back in the day, right? So it's a criminal trial. Keep that in mind, which is interesting, right? Of Susan B. Anthony, a U.S. federal court in 1873. The defendant was a leader of the women's suffrage movement who was arrested for voting in Rochester, New York in the 1872 elections in violation of state laws that allowed only men to vote. Anthony argued that she had the right to vote because of the recently adopted 14th Amendment to the U.S. Constitution, which we all know is horseshit. We're going to get into that in a second. The Judge Ward Hunt was a recently appointed U.S. Supreme Court justice who had responsibility for the Federal Circuit Court in which the trial was held. So this is important. Let's jump into this. So this is Ward Hunt. This is the justice, the judge on this case. Now, back during this time period, it was before we had the appeals courts. So you have the Federal Circuit Court, and then you have the U.S. Supreme Court, and that's it. That's all there was at this time, right? I think until 1891, right? So the way it works is if the Federal Circuit zone didn't have people to run the Federal Circuit Court, the U.S. Supreme Court justice that was responsible for that zone would have to basically go on saddleback. And they actually have a term for it called a riding circuit in saddleback, or riding circuit. They had these various terms. That means literally, no joke, these guys would get on a fucking horse. Dude, so badass, right? Like the most American shit ever. These guys would literally get on a fucking horse and they would ride like every couple of weeks or every month or whenever there was cases that needed to get handled in the federal. If there wasn't someone there to handle these federal circuit cases, the U.S. Supreme Court justices that were all, you can see here, he was recently appointed to the U.S. Supreme Court who had responsibility for the Federal Circuit Court in which the trial was held. So if you go down the rabbit hole of what that meant, it meant that like each U.S. Supreme Court justice had like a zone, and he had to either, I don't really know all the details, but he had to either get a judge to work in that area, or if there was no judge, or if they were sick, or if they were gone, or if they were on vacation, he has to get on a fucking horse and go down there and be the now this is important though, because we have so it's the whole case law versus persuasive authority thing, right? So because it was a Federal Circuit case, technically it's not case law, it would be persuasive authority. But I think where this case really is interesting is you have a Supreme Court justice riding circuit coming down, and then he's acting within the capacity of a Federal Circuit judge. So when we go through this case, for me, it's interesting on more of a personal level than it is on like a litigation level. It is interesting on a litigation level, but it's even more interesting on a personal level. And the reason why is some of the things we're going to go over in this case is so shocking that even for us, I'm telling you, when we start reading this thing, I was sitting here, oh man, my jaw was on the ground reading this case, literally, right? Now, let's say you've got a bar card brother or a bar card friend or a bar card dad or a bar card grandpa, right? The reason why you send them this case, and the reason why it's interesting is, yes, fine, in a litigation standpoint, it may only be considered persuasive authority. It's not case law, it's persuasive authority, right? But the idea that this is a U.S. Supreme Court justice saying these things gives a lot of weight to the case and what is being said in the case. And that's why I think it's so fascinating, because yes, we're going to be using this in cases. There's no question about it. I don't care if it's persuasive authority. I don't care nothing. I'm going to say the following is persuasive authority, but I'd like to bring it to the attention of the court that Mr. Hunt was actually a U.S. Supreme Court justice who was riding circuit on this case. So even though it is just technically and legally persuasive authority, I feel like it should be given more weight due to the justice involved. And plus, it was right around the same time period that the 14th Amendment was happening, the slaughterhouse cases was happening. He was hanging out with Samuel Freeman Miller, because him and Miller were both contemporaries in the Supreme Court. They were both associate Supreme Court justices. So it's like, this is like top tier from the horse's mouth. That's kind of why I'm so excited about it, right? So it's a criminal case for voting, right? And one of the things I wanted to show you guys too is we go down this list of different courts. This is on oyez.org/courts. And it shows us each court, right? And if we go all the way down, we can see Ward Hunt. Let's take a look at his background, right? So he was the 11th mayor of Utica in New York State from 1844 to 1855. He was born in 1810, so he would have been 34 when he became the mayor. 34 to 45, he was the mayor. So at 45, oh wow. No, so years went by before he became a chief judge of the New York Court of Appeals. Well, that's interesting. I don't know how that works because I read that there wasn't a court of appeals. Oh, this is on the state side. Okay. So in state court, so he was a state court chief judge of the state of New York State Court of Appeals. That makes sense. Because the case that we're going to look at here, the Susan B. Anthony case, was a federal case. With the federal cases we had at this time, the federal circuit and then the U.S. Supreme Court. So this makes sense. Now I'm tracking now. So he was 58 years old when he became the chief judge of the New York State Court of Appeals. And then he was there for just 2 years. Because if you look, it's right at the very beginning of the 1 year and then right at the very end of the next one, right? Then he became the Associate Justice of the U.S. Supreme Court right after the Slaughterhouse cases, actually. Slaughterhouse, well, actually, let's see here. Uh, 1873. Decided April 14th, 1873. Okay. So he probably already knew a lot of the stuff that was going on with a lot of that stuff, with the Slaughterhouse stuff, because it had been going on. Because it was argued January 11th, 1872, and then re-argued February 3rd to 5th, 1873. So they had already been talking about this stuff for a while. That's probably how that's how Mr. Hunt really kind of knows what he's going to say in this case, because this case, well, hold on a second. This case, what's the date? Argued June 17th, okay. No, I'm wrong. This is right after. So April 14th, 1873, and then right after we have June 17th, 1873, Susan B. Anthony. So it's like literally right on the heels of the Slaughterhouse cases. And Ward Hunt was in office January 9th of 1873. So he would have been there for the re-argument and then the decision. So I'm telling you, this is the reason why this case is so big, is he was right there, bro. Right there. I mean, this might as well be Samuel Freeman Miller talking in this case. And what he has to say is going to really shock you. So I'm trying to set this up so that you understand why I'm so excited about it. I'm kind of shocked. I've had several people message me and be like, hey, man, you should check out the Susan B. Anthony thing. I don't know why I didn't. I guess just because it's a little bit hard to access, because I don't think you can get it from normal, because it's a circuit court case. I will put, you know what I'm going to do? I'm actually going to Dropbox this file, and I'll put a link down in the video description. And then this video is also going to go on the case critiques page on W&W. I'll put a link to the original, this PDF on there as well. Okay, guys, so you'll have that. Anyways, I wanted to show you this. So we have the court when Mr. Hunt began, right around here. Here he is, right? Here's where he starts, right? But if we go up, check this out. Open image and new tab. Look at this. Guess where your boy's at? Free man. Free man. Pretty cool, right? I can draw on here now. So this is Chief Justice Waite here in the center. Morrison R. Waite, but he had a nickname. I forget his nickname. Morrison R. I forget, but Morrison R. Waite. Remick. Mott. Yeah, that was his nickname, I think, is Mott. What a weird nickname, right? Kind of a gangster-looking motherfucker, right? So he is right here. And then I believe this is Ward Hunt, the guy that we're going to hear from in this case. Because you can see this is what he looks like from the front. And you can see what he looks like from the side here. God, these are awful pictures. Let's go back. You can see what he looks like here from the side. He's got these big old mutton chops. Oh, big old babies. Let's see here. Oh, he had a beard. Oh no, that's a different person. I don't know. It looks to me like this is him here on the end. You can see them big old mutton chops and that nose. I don't know. Looks like him to me. So I'm just showing you this to just show you, like, he was there, bro. Like, we're going to hear from a guy who was literally there for everything. Like, top tier from the horse's mouth. All right? And, bro, you better buckle up. I'm telling you. Here we go. So here's the case. This is the summary. We're going to skip the summary. We're going to go straight into the case itself, right? The defendant, Susan B. Anthony, a female. I'm going to zoom in just a tad because I want to make this real big for you. The defendant, Susan B. Anthony, a female, was indicted for a violation of the 19th section of the Act of May 31st, 1870, which provides, quote, that if at any election for representative in the Congress of the United States, any person shall knowingly vote without having a lawful right to vote, every such person shall be deemed guilty of a crime and shall, for such crime, be liable to prosecution in any court of the United States of competent jurisdiction, and on conviction thereof shall be punished by a fine not exceeding $500 or by imprisonment for a term not exceeding 3 years or both in the discretion of the court, and shall pay the costs of prosecution. The trial took place before Hunt, Circuit Justice, and a jury. There was no dispute that the defendant had voted for a representative in the Congress of the United States at an election therefore in Rochester, Monroe County, New York, and that under the construction and laws of the state of New York, none but males were authorized to vote at an election for members of the most numerous branch of the state legislature, and that the defendant possessed all the qualifications entitling a person to vote at such election, except that she was not a male. Richard Crowley was the district attorney for the United States. Henry R. Selden looks like he was the attorney for Susan B. Anthony. Hunt. circuit justice, after argument had been heard on the legal questions involved, ruled as follows. The defendant is indicted under the Act of Congress of May 31st, 1870, for having voted for a representative in Congress. In November 1872, among other things. Actually, you know what? I'm going to stop. I want to check something. How many members of, I'm just curious, of the Supreme Court were slave owners? Oh no, because it was the 13th Amendment. When the 13th Amendment was passed? Question mark. No, not histories. I don't want the history. List of United States Supreme Court justices who owned slaves. Yeah, but I want dates. I want to see, yes, from what years to what years. Okay. Maybe that'll work. Let's take a look at this real quick. Roger B. Taney. Deeply committed to slavery? No, he wasn't. That's not true. Let's see here. Samuel Freeman Miller. No, from these dates. Oh, I see. Hold on a second. Oh, yeah. Roger B. Taney was a no through his no. Anyways, I don't really want to get into this much more than this. I'm just kind of curious. Having voted for a representative in Congress in November 1872, among other things, that act makes it an offense for any person knowingly to vote for such representative without having a lawful right to vote. It is charged that the defendant thus voted, she not having the right to vote, because she is a woman. The defendant insists that she has a right to vote and that the provision of the Constitution of the state limiting the right to vote to persons of the male sex is in violation of the 14th Amendment of the Constitution of the United States and is void. The 13th, 14th, and 15th Amendments were designed mainly for the protection of the newly emancipated Negroes, but full effect must, nonetheless, be given to the language employed. The 13th Amendment provides that, quote, neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. If honestly received and fairly, end quote. If honestly received and fairly applied, this provision would have been enough to guard the rights of the colored race. In some states, it was attempted to be evaded by enactments, cruel and oppressive in their nature. Talking about the black codes, for those of you who may be aware of what that is. As that colored persons were forbidden to appear in the towns except in a menial capacity, and they should reside on and cultivate the soil without being allowed to own it. Sound like something today? They were not permitted to give testimony in cases where a white man was a party. They were excluded from performing particular kinds of business, profitable and reputable, and they were denied the right of suffrage. To meet the difficulties arising from this state of things, the 14th and 15th Amendments were enacted. Now again, I've already said, I'm going to say it again. This is by a dude who's literally right in there. He's going to say a lot more shocking stuff, but you guys got to realize he's right up there with all the good old boys, right in the middle of all of this. So like people want to talk about later cases and stuff like that and other stuff and all this and that. This is the literal heart of the fucking beast. There's no case after this point. Like the closer you get to the slaughterhouse cases, the closer you get to the 14th Amendment, the closer you get to Samuel Freeman Miller, the better the information can be trusted. Because this guy, Ward Hunt, he's there. He's literally there when everything is happening. So I'm gonna bang on that a couple more times during this, just to kind of, because it's just so important to understand that during this case. Okay. The 14th Amendment creates and defines citizenship of the United States. It had long been here's where things get, hold on to your hats, hold on to your chairs. It had long been contended and had been held by many learned authorities and had never been judicially decided to the contrary, that there was no such thing as a citizen of the United States, except as that condition arose from citizenship of some state. No mode existed, it was said, of obtaining a citizenship of the United States, except by first becoming a citizen of some state. This question is now at rest. The 14th Amendment defines and declares who shall be citizens of the United States, to wit, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof, end quote. The latter qualification was intended to exclude the children of foreign representatives and the like, which Mr. Miller talks about and gives all the details on in the slaughterhouse cases. So that part is actually not as good as what Mr. Miller says in the slaughterhouse cases. He's much more specific, talking about people of foreign states, talking about ministers, talking about consuls. Mr. Miller in the slaughterhouse cases is actually more explicit on that last part of subject to the jurisdiction thereof than Mr. Hunt is. But Mr. Hunt is better in some areas than Mr. Miller is on this. You'll see in a moment. With this qualification, every person born in the United States or naturalized is declared to be a citizen of the United States and of the state wherein he resides. After creating and defining citizenship of the United States, the 14th Amendment provides that, quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, end quote. This clause is intended to be a protection, not to all our rights, but to our rights as citizens of the United States only. That is, to rights existing or belonging to that condition or capacity. The expression citizen of a state used in the previous paragraph is carefully omitted here. So let's go back here. This clause is intended to be a protection. This clause is intended to be a protection, not to all our rights, but to our rights as citizens of the United States only. That is, to rights existing or belonging to that condition or capacity. The expression citizen of a state used in the previous paragraph is carefully omitted here. In Article 4, Section 2, Subsection 1 of the Constitution of the United States, it had been already provided that, quote, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states, end quote. The rights of citizens of the states and of citizens of the United States are each guarded by these different provisions. That these rights are separate and distinct was held in the slaughterhouse cases, recently decided by the Supreme Court. The rights of citizens of the state as such are not under consideration in the 14th Amendment. That's a huge one. Again, the rights of citizens of the state as such are not under consideration in the 14th Amendment. That goes with Bradwell v. State, which he will talk about that in this as well. Bradwell v. State was done the day after Slaughterhouse. So August 15th, 1873. I'm sorry, April 15th, 1873 would be Bradwell v. State, right? This is it right here. This right here is the part where I was like, my jaw hit the ground, right? So the rights of citizens of the state as such are not under consideration in the 14th Amendment. They stand as they did before the adoption of the 14th Amendment and are fully guaranteed by other provisions. The rights of citizens of the states have been the subject of judicial decision on more than one occasion, and he gives a bunch of cases. We're probably going to eventually cover some of these cases, right? I'll probably do some videos on these cases too, because these are probably hot, right? These are the fundamental privileges and immunities belonging of right to the citizens of all free governments, such as the right of life and liberty, the right to acquire and possess property, to transact business, to pursue happiness in his own manner, subject to such restraint as the government may adjudge to be necessary for the general good. In Crandall v. Nevada, is found a statement of some of the rights of a citizen of the United States. For example, to come to the seat of government to assert any claim he may have upon the government, right? Now, keep in mind when they say to come to the seat of government to assert any claim he may have upon the government, where does that terminology come from? That terminology comes from 4 U.S.C. 71, which I'm sure comes from, if you go down to the bottom here, it comes from 61 stat 643, and it probably goes back to whatever, but you can see here all that part of the territory of the United States included within the present limits of the District of Columbia shall be the permanent seat of government of the United States. Right? To transact any business he may have with it, to seek its protection, to share its offices, to engage in administering its functions, and to have free access to its seaports, through which all the operations of foreign commerce are conducted, to the sub-treasuries, the land offices, the revenue offices, and the courts of justice in the several states. Quote, another privilege of a citizen of the United States, end quote, says Mr. Miller in the slaughterhouse cases, quote, is to demand the care and protection of the federal government, because they're federal citizens, right, over his life, liberty, and property when on the high seas or within the jurisdiction of a foreign government. And this idea of the protection of his life, liberty, and property when on the high seas or within the jurisdiction of a foreign government, that goes back to you can even go back and read like 42 USC 1983, right? Civil action for deprivation of rights under color of law, right? So every person of any state, territory of the District of Columbia subjects or caused to be subject any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities. So it's federal protections for state damages. But it's mainly for citizens of the United States. It's not for state citizens to use. It's for federal citizens to use. Federal U.S. citizens, right? So, and then the other area I wanted to show you guys is this area here, 18 USC 7. So a lot of people in the sovereignty space, they're always talking about admiralty maritime law. You can actually see that here on 18 U.S.C. 7. So this actually is probably one of the best places I've ever seen that actually describes that. And then there's also another type of jurisdiction. So there's actually two types of special jurisdiction on behalf of the federal government or the District of Columbia. One of them is the Maritime Admiralty, which I don't think has really much to do with anything, to be honest with you. And then we have another one called territorial. Now, that's the one that I think they're actually using all the time. Because if you go down, it says here, any lands reserved or acquired for the use of the United States, which means the District of Columbia, and under the exclusive or concurrent jurisdiction thereof. The exclusive or concurrent jurisdiction thereof, or any place purchased or otherwise acquired by the United States by the consent of the legislature of the state in which the same shall be. So like American Samoa, a fort, the Virgin Islands, an arsenal, a dockyard, needful building, right? These are all part of the territorial jurisdiction. If you were on a boat or something and you were in the ocean, it could be maritime admiralty, but I don't think any of that really is what they're really trying to apply. I think what they're trying to apply is this special territorial jurisdiction. That's the one that everybody's running into. Whenever you see anybody in the sovereignty space saying, oh, vessels and admiralty, maritime and all that, it's actually not that. I think it's actually this, territorial, special territorial jurisdiction. Now, anything that's within this admiralty, maritime, or special territorial jurisdiction operates under 4 U.S.C. 72. All offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law, and that's how the federal courts get jurisdiction over the matter. If there's a special maritime or special, so if we go to 28 U.S.C. 1331, I believe it is, which is the federal question, and we go back one checkbox, right? Maybe two. Jurisdiction. So in 28 U.S.C. 85 Part 4, District Courts jurisdiction, and we go down, this is all the different ways that somebody can gain jurisdiction in a federal court, right? Actions against foreign states. Federal question, that's one that most people know. Diversity of citizenship, that's one people know. Admiralty, maritime, and prize cases. Any civil case of admiralty or maritime jurisdiction, saving to suitors in all cases, all other remedies, right? And then I guarantee you, if we go down here, we're going to see territorial. Taxes by state. United States is plaintiff. United States is defendant. That's interesting. What is that? Interesting. Banking association as party. Interesting. Consuls, vice consuls, and members of a diplomatic mission as defendant. That's interesting. Indian allotments. Injuries under federal laws. Interesting. Well, I'm not not seeing the territorial. It's got to be here. Admiralty, Maritime, Federal Question, Postal Matters, Civil Rights and Elective Franchise. What is this? Oh, yeah. Huh. It's got to be here. Let's see. Aliens. Seizures not within Admiralty and Maritime jurisdiction. Indian tribes. I might need to dig into this more, but I guarantee you it's here. It's got to be here. So you have the two special jurisdictions, right? High seas or within the jurisdiction of a foreign government. But that has a little bit more to it. The foreign government part has to be a little bit more to it, right? Quote here, the right to peacefully assemble and petition for redress of grievances, the privilege of the writ of habeas corpus, end quote. He says, quote, are rights of the citizen guaranteed by the federal constitution, end quote. The right of voting or the privilege of voting is a right or privilege arising under the constitution of a state and not under the Constitution of the United States. The qualifications are different in the different states. Citizenship, age, sex, residence are variously required in the different states, or maybe so. If the right belongs to any particular person, it is because such person is entitled to it by the laws of the state where he offers to exercise it, and not because of citizenship of the United States. If the state of New York should provide that no person should vote until he had reached the age of 30 years or after he had reached the age of 50, or that no person having gray hair or who had not the use of all his limbs should be entitled to vote, I do not see how it could be held to be a violation of any right derived or held under the Constitution of the United States. We might say that such regulations were unjust, tyrannical, unfit for the regulation of an intelligent state. But if rights of a citizen are thereby violated, they are of that fundamental class derived from his position as a citizen of the state and not those limited rights belonging to him as a citizen of the United States. So, and such was the decision in Cornfield versus Coriel. The United States rights appertaining to this subject are those, first, under Article 1, Section 2, Subdivision 1 of the United States Constitution, which provides that electors of representatives in Congress shall have the qualifications requisite for electors of the most numerous branch of the state legislature. And second, under the 15th Amendment, which provides that, quote, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude, end quote. If the legislature of the state of New York should require a higher qualification in a voter for a representative in Congress than is required for a voter for a member of the House of Assembly of the state, this would, I conceive, be a violation of a right belonging to a person as a citizen of the United States. That right is in relation to a federal subject or interest and is guaranteed by the federal Constitution. The inability of a state to abridge the right of voting on account of race, color, or previous condition of servitude arises from a federal guarantee, its violation would be the denial of a federal right, that is, a right belonging to the claimant as a citizen of the United States. This right, however, exists by virtue of the 15th Amendment. If the 15th Amendment had contained the word sex, the argument, so this is interesting here too. We have this right, however, exists not by virtue of the Constitution itself, which is for state citizens, but this right exists by virtue of the 15th Amendment for a citizen of the United States. Totally separate class, right? If the 15th Amendment had contained the word sex, the argument of the defendant would have been potent. She would have said that an attempt by a state to deny the right to vote because one is a particular sex is expressly prohibited by that amendment. The amendment, however, does not contain that word. It is limited to race, color, or previous condition of servitude. The legislature of the state of New York has been fit to say that the franchise of voting shall be limited to the male sex. In saying this, there is, in my judgment, no violation of the letter or of the spirit or of the 14th or 15th Amendments. This view is assumed in the second section of the 14th Amendment, which enacts that if the right to vote for federal officers is denied by any state to any of the male inhabitants of such state, except for crime, the basis of representation of such state shall be reduced in proportion specified. Not only does this section assume that the right of male inhabitants to vote was the special object of its protection, but it assumes and admits the right of a state, notwithstanding the existence of that clause, under which the defendant claims to the contrary to deny to classes or portions of the male inhabitants the right to vote, which is allowed to other male inhabitants. So even the 14th Amendment, Section 2, says that it's for men, basically. The regulation of the suffrage is thereby conceded to the states as a state's right. The case of Bradwell v. State, this is the one I was just talking about, decided at the recent term of the Supreme Court, sustains both of the positions above put forth. For example, first, that the rights referred to in the 14th Amendment are those belonging to a person as a citizen of the United States and not as a citizen of a state. Huge. Monstrous. And second, that a right of the character here involved is not one connected with citizenship of the United States. Mrs. Bradwell made application to be admitted to practice as an attorney and counselor at law in the courts of Illinois. Her application was denied, and upon a writ of error, which means going to appeals at this time period, it was held by the Supreme Court that to give jurisdiction under the 14th Amendment, the claim must be of a right pertaining to citizenship of the United States, and that the claim made by her did not come within that class of cases. Justices Bradley, Swain, and Field held that a woman was not entitled to a license to practice law. It does not appear that the other judges passed upon that question. The 14th Amendment gives no right to a woman to vote, and the voting by Miss Anthony was in violation of law. If she believed she had a right to vote and voted in reliance upon that belief, does that relieve her from the penalty? It is argued that the knowledge referred to in the act relates to her knowledge of the illegality of the act and not to the act of voting, for it is said that she must know that she voted. Two principles apply here. First, ignorance of the law excuses no one. Very interesting. Second, every person is presumed to understand and to intend the necessary effects of his own acts. Miss Anthony knew that she was a woman and that the Constitution of this state prohibits her from voting. She intended to violate that provision, intended to test it perhaps, but certainly intended to violate it. The necessary effect of her act was to violate it, and this she is presumed to have intended. There was no ignorance of any fact, but all the facts being known, she undertook to settle a principle in her own person. She takes the risk, and she cannot escape the consequences. It is said, and authorities are cited to sustain the position, that there can be no crime unless there is a culpable intent. Culpable intent. I looked this up last time I recorded this video, and it crashed on me. And I found this really cool thing. Hopefully I can find it again. I should have saved it. Oh, here it is. Here we go. This was really cool. I found this on the last time I shot this video, and it crashed. Culpable intent is like a spectrum, right? It's got strict liability. Strict liability, civil negligence, criminal negligence, recklessly, extreme reckless, knowingly, intentionally, and then premeditated. Is sort of like a scale of culpable intent. Really, I thought that was really cool. And that to render one criminally responsible, a vicious will must be present. A commits a trespass on the land of B, and B, thinking and believing that he has a right to shoot an intruder upon his premises, kills A on the spot. Does B's misapprehension of his rights justify his act? Would a judge be justified in charging the jury that if satisfied that B supposed he had a right to shoot A, he was justified and they should find a verdict of not guilty? No judge would make such a charge. To constitute a crime, it is true that there must be a criminal intent, but it is equally true that knowledge of the facts of the case is always held to supply this intent. An intentional killing bears with it evidence of malice in law and a desire to promote the welfare of the deceased by his translation to a better world would be no justification of the act were it committed by a sane man. Whoever, without justifiable cause, intentionally kills his neighbor is guilty of a crime. The principle is the same in the case before us and in all criminal cases. The precise question now before me has been decided several times. That one illegally voting was bound and was assumed to know the law, and that a belief that he had a right to vote gave no defense if there was no mistake of fact. And then he gives some examples of some cases. No system of criminal jurisprudence can be sustained upon any other principle. Assuming that Miss Anthony believed she had a right to vote, that fact constitutes no defense. If, in truth, she had not the right, she voluntarily gave a vote which was illegal and thus is subject to the penalty of law. This is actually really interesting because if we go back to her trial and we go down, she had a pre-speaking tour. She turned it into an opportunity to generate publicity for the suffrage movement. She spoke in 29 towns and villages where her trial was to be held and which would provide the jurors for her trial. Her speech was entitled, "Is it a crime for a U.S. citizen to vote?" She said the 14th Amendment gave her that right, blah, blah, blah. One of the things she said here is really funny, actually. Anthony then argued that the only question left to be settled now is, are women persons? And I hardly believe any of our opponents will have the hardihood to say they are not. They aren't, bitch. I mean, if they're Negroes, if they're of African blood, yeah, sure, but Not you. Sorry. Well, I'm not sorry, actually, because why would you, that's the stupidest fucking thing in the world, calling yourself a U.S. citizen. Being persons, then, women are citizens, and no state has a right to make any new law or to enforce any old law that shall abridge their privileges or immunities. So she's just has no clue. She has no clue what's going on. It's fucking hilarious, right? It's funny she was on the right word, though. She found the right word, just didn't have the right definition for it. She was so close. Upon the foregoing ruling, the counsel for the defendant requested the court to submit the case to the jury on the question of intent, and with the following instructions. 1, if the defendant at the time of voting believed that she had a right to vote and voted in good faith in that belief, she is not guilty of the offense charged. 2, in determining the question whether the defendant did or did not believe that she had a right to vote, the jury may take into consideration, as bearing upon that question, the advice which she received from the counsel to whom she applied, and also the fact that the inspectors of the election considered the question and came to the conclusion that she had a right to vote. 3, the jury have a right to find a general verdict of guilty or not guilty, as they shall believe that the defendant has or has not committed the offense described in the statute. The court declined to submit the case to the jury on any question and directed the jury to find a verdict of guilty. Now, this is where they get all pissy. You'll read a lot of stuff about how, he's an asshole because he just told the jury to basically find her guilty. But it actually makes perfect sense, and he's going to explain why here. A request by the defendant's counsel that the jury be polled was denied by the court, and a verdict of guilty was recorded. On a subsequent day, a motion for a new trial was made on the part of the defendant before Hunt Circuit Justice, right? And he denied the motion, and this is what he explains why, and it's actually a great explanation. He's actually correct here, by the way. The whole law of the case has been re-argued, and I have given the best consideration in my power to the arguments presented. But for the evident earnestness of the learned counsel for the defendant, for whose ability and integrity I have the highest respect, I should have no hesitation. Still, I can entertain no doubt upon any point in the case. I do not doubt the correctness of my decision that the defendant had no right to vote, and that her belief that she had a right to vote, she knowing all the facts and being presumed and bound to know the law, did not relieve her from the penalty for voting, when in truth she had no right to vote. The learned counsel insists, however, that an error was committed in directing the jury to render a verdict of guilty. This direction, he argues, makes the verdict that of the court and not of the jury, and it is contended that the provisions of the Constitution looking to and securing a trial by jury in criminal cases has been violated. The right of trial by jury in civil as well as in criminal cases is a constitutional right. For civil cases, it's a little bit different for U.S. citizens than it is for state citizens, but this is mostly correct. The second section of the first article of the Constitution of the State of New York provides that, quote, the trial by jury in all cases in which it has been heretofore used shall remain inviolate forever, end quote. Articles 6 and 7 of the amendments to the Constitution of the United States contain a similar provision, yet and then keep in mind, 6 is only partially incorporated for U.S. citizens, and 7 has never been incorporated for U.S. citizens in accordance with the incorporation doctrine cases. So keep that in mind. They weren't talking about any of that at this time. That wasn't until later. So just keep that in mind now. It's important to understand that about 6 and 7, right? Yet, in cases where the facts are all conceded, or where they are proven and uncontradicted by evidence, it has always been the practice of the courts to take the case from the jury and decide it as a question of law. No counsel has ever disputed the right of the court to do so. No respectable counsel will venture to doubt the correctness of such practice, and this in cases of the character which are usually submitted to a jury. So what he's saying is, the jury can't figure out the law. That's my job. That's the court's job. And the law has to be sustained more so than just a bunch of fucking retards in a box. So like matters of law go to the court and matters of fact go to the jury. But because the situation of the law in this case was so cut and dry, there was no reason to, nor did we have any questions of fact. Fact was not something that even needed to be evaluated because law was already established and it was already a clear situation regarding the law. So the jury didn't need to actually evaluate anything. Like their job was, let me give you another example. Like if the judge's job is to clean the meat and the jury's job is to clean the vegetables, he's saying all there is here is meat. There are no vegetables. There are no vegetables for the jury to even look at. And even if there were, there's no point to bother because the meat already tells us everything, and that's the end of it. We're not going to let a bunch of locals, a bunch of who knows what, farmers or whatever, decide something above and beyond the law. Otherwise, you would destroy the entire substructure of everything. The law itself would start to deteriorate and unravel if everyone just decided their own stuff. All the juries across the whole country, and every single jury just decided whatever they wanted to decide, and the law wasn't considered senior to that. We would have pandemonium, and the whole country would explode in 10 seconds. That's basically what he's saying in English, right? Which is 100% true. He's 100% correct. So people say he's a total asshole and all this kind of stuff. No, absolutely not. He was hard as fuck about the law, and he wasn't ever going to let anyone fuck with the law or change the law or undermine the law for absolutely literally any fucking reason. Even though he had a lot of respect for the representation for Susan B. Anthony, the attorney, as you said earlier, he's like, I'll talk about this a little bit more because I respect you, but there's nothing to talk about here, essentially. And he's right, by the way. He's actually 100% right. The right of a trial by jury in a criminal case is not more distinctly secured than it is in a civil case. In each class of cases, this right exists only in respect of a disputed fact. To questions of fact, the jury responds. See? That's what he's talking about here. To questions of fact, not of law, of fact, the jury respond, right? Upon questions of law, the decision of the court is conclusive. And that makes sense. You got a guy who is a judge, his job is to know and understand the law, and like he's talking about all this legal stuff that comes from our legal system. The jury's not going to know a lot of that shit. It makes perfect sense, honestly, when you really look at it, right? And the jury are bound to receive the law as declared by the court. If this didn't exist, the entire legal structure would just unravel in like a month or two, right? Because people would go in there, I think everybody, I think there shouldn't be any guns for anybody, and then like bang, and then everybody, it would just be a mess, right? Just opinions, right? This prevents that from happening. Such is the established practice in criminal as well as in civil cases, and this practice is recognized by the highest authorities. It has been so held by the former Supreme Court of this state and by the present Court of Appeals of this state. As a circuit court of the United States, held by Judges Woodruff and Blatchford upon deliberation and conclusion, it was decided that in a criminal case, the court was not bound to submit the case to the jury, there being no sufficient evidence to justify a conviction, and the court accordingly instructed the jury to find a verdict of not guilty. The district attorney now states that on several occasions since he has been in office, Judge Hall, being of opinion that the evidence did not warrant a conviction, has directed the jury to find a verdict of not guilty. In the case of People v. Bennett, the Court of Appeals of the state of New York, through its Chief Justice, uses the following language. Quote, contrary to an opinion formerly prevailing, it has been settled that the juries are not judges of the law as well as the facts in criminal cases, but that they must take the law from the courts. All questions of law during the trial are to be determined by the court, and it is the duty of the jury to regard and abide by such determination. It's still like that today, by the way. So when you go into court, all questions of law go to the court. All questions of fact go to the jury, right? I can see no reason, therefore, why the court may not, in a case presenting a question of law only, instruct the jury to acquit the prisoner or to direct an acquittal and enforce the direction, nor why it is not the duty of the court to do so. This results from the rule that the jury must take the law as adjudged by the court, and I think it is a necessary result, end quote, right? In these cases, the question in each instance was whether the court had power to direct a verdict of not guilty to be rendered. But the counsel for defendant expressly admits that the authority which justifies a direction to acquit will, in the proper case, justify a direction to convict. So he's saying that in the previous example, they gave an example of the ability to get the guy acquitted. He's saying, well, that should also apply to conviction, which is true. It should. I mean, I don't disagree with anything he's saying here, right? That is the question of power, and that if the power may be exercised in favor of the defendant, it may be exercised against him. As I now state this proposition, the counsel again signifies his assent. The reason given by Chief Justice Church in the case just cited shows that there is no distinction between the cases in this respect. He says the rule results from the principle that the jury must take the law from the court. The duty of the jury to take the law from the court is the same, whether it is favorable to the defendant or unfavorable to him. It is laid down in Colby something that no jury shall in any case be compelled to give a general verdict so that they find the facts and require the court to give judgment thereon. Quote, a special verdict is given when the jury finds certain facts to exist and leave the court to determine whether, according to law, the prisoner is guilty, end quote. Quote, it is not necessary that the jury should, after stating the facts, draw any legal conclusion. If they do so, the court will reject the conclusion as superfluous and pronounce such judgment as they think warranted by the facts. Superfluous? Superfluous, right? Unnecessary, especially through being more than enough. Unnecessary. So basically, if the jury draws any legal conclusions, the court rejects those as unnecessary, basically like opinion, and the court is responsible for ensuring that whatever's going on sticks with the present legal system and doesn't just allow anyone to just kind of go off on their own and just totally destroy everything, and then in 10 minutes there's not going to be a legal system anymore. That's what this is in English, right? All the authorities tend to the same result. It is the duty of the jury to act upon the facts. It is the jury of the court to decide the law. The facts being specially found by the jury, it is the duty of the court and not of the jury to pronounce the judgment of guilty or not guilty. The facts being conceded, it is the duty of the court to announce and direct what the verdict shall be, whether guilty or not guilty. Therefore, I cannot doubt the power and the duty of the court to direct a verdict of guilty whenever the facts constituting guilt are undisputed. In the present case, the court had decided as a matter of law that Miss Anthony was not a legal voter. It had also decided as a matter of law that, knowing every fact in the case and intending to do just what she did, she had knowingly voted, not having a right to vote, and that her belief did not affect the question. Every fact in the case was undisputed. There was no inference to be drawn or point made on the facts that could, by possibility, alter the result. It was, therefore, not only the right, but it seems to me, upon the authorities the plain duty of the judge to direct a verdict of guilty, which I agree with, actually. I think he's completely right. The motion for a new trial is denied. The defendant was thereupon sentenced to pay a fine of $100 and the costs of the prosecution. And then she was not put in jail. If she would have been put in jail, she would have had the right to write a writ of habeas corpus and go to the Supreme Court for an appeal. And the judge never gave her any jail time, so she couldn't appeal. And then she never paid the $100 fine ever, I don't think, till the day she died. So interesting. Some of the things that are said in there is really, really fascinating. So I hope you guys find this as interesting as I do, because this is a hell of a case. We're definitely going to be using this as persuasive authority, no question about it. Hope you guys love the video. Hope you guys like the new system I have here. Let me know what you think on that. And yeah, that's it. See you guys later.